Prince William, standing alongside Princess Anne and the Duchess of Edinburgh, told the press, "The marriage agreement of February 15th between Prince Harry and Meghan Markle is now official. And with that, there are irreversible consequences. The Crown has acted in accordance with its ancient duty to protect, to uphold, and to serve its future. The settlement reflects this principle. It is final." Prince William, the declaration marked the end of a private war that had long spilled into public consciousness. Within the palace walls, the path to this moment was neither swift nor uncontested. The turning point had arrived earlier, during the early hours of the 3rd of February 2026, when Princess Anne presented the now notorious Markle withdrawal file in an emergency session with King Charles and Prince William at Windsor Castle. The dossier, stamped immediate custodial breach, detailed how Meghan had withdrawn Archie, 7, and Lilibet, 5, from their California schools without notice, blocked medical appointments, severed communication with royal child welfare officers, and most damning, authorized the dissolution of a £6.3 million education trust established for the children in the UK. More than negligence, the file presented what Anne termed a structured pattern of disengagement. By February 4, Duchess Sophie was authorized to activate the Royal Emergency Guardianship Protocol, a legal mechanism last used during the post-war succession instability of the 1950s. The following day, Prince William invoked Appendix 4 of the Royal Succession Stabilization Act, a clause dating back to the Edward VIII abdication crisis, granting the Crown full custodial control over minors of royal descent in the face of existential threat or erasure of identity. Meghan Markle was not present during any of the proceedings. Her legal team submitted no challenge. Her silence, according to palace aides, spoke louder than any opposition. The February 15 agreement, signed under legal observation at the Royal Family Court of Chancery, covered 6 main categories. Division of joint assets, including real estate in Montecito, Norfolk Holdings, stock accounts, and liabilities tied to Archewell. Custody and child welfare, granting the Crown permanent legal guardianship of Archie and Lilibet. Financial support and obligations, outlining child support responsibilities and education funding. Personal property and premarital assets, defining exclusive ownership of heirlooms, inheritances, and IP rights. Residential access and transitional housing, settling who may reside in former marital properties. Public conduct and confidentiality clauses, including non-disparagement, media engagement bans, and penalties for breach. The palace emphasized that while the legal components were binding, the emotional consequences were ongoing. A source close to Queen Camilla, who did not appear publicly, confided that the Queen felt immense sadness but total relief after the terms were sealed. For Prince Harry, the weeks leading up to the signature were described as internally fractured. Aides said he had suffered bouts of withdrawal, confusion, and guilt. Without Meghan's presence in the UK, he reportedly vacillated between defense and surrender, ultimately yielding to the Crown's constitutional position after being denied interim custody due to his unstable residency status and lack of consistent income. Meanwhile, Princess Catherine was photographed leaving St. George's Chapel with Lilibet and Charlotte on February 10, hand in hand, as a symbolic gesture of transition. The photo, released without caption, ignited a flood of public sympathy and admiration. British media hailed it as the moment dignity eclipsed dysfunction. The official public release of the marriage settlement followed the customary 4-8-hour constitutional waiting period. On the 17th of February 2026, at precisely 9, Buckingham Palace uploaded the announcement to its formal channel. Within minutes, headlines spanned both sides of the Atlantic. The Times, Royal Guardianship secured Meghan relinquishes all rights. The Telegraph, custody crisis resolved, under royal doctrine. New York Post, Megxit to the final exit. But within the pages of the 1-7 clause agreement lay hints of deeper discord. Meghan had refused to sign Clause 11, which permanently banned the use of the children's names or images for commercial purposes. Palace sources confirmed that this clause remains disputed and suspended, pending further review. While William stood at the helm of the public announcement, it was Anne who set the tone behind closed doors. Her quote to royal aides, later leaked anonymously, summed up the institutional ethos. "We did not ask for this battle, but once it threatened the children, it became our responsibility to win it." The monarchy, battered but intact, had closed a chapter that had stretched the meaning of duty to its constitutional and emotional limits. And the world, watching in real time, knew one truth above all. This was no ordinary divorce. It was a royal reset signed, sealed, and sovereign. The confidential dissolution agreement, signed on the 15th of February 2026, was no ordinary divorce decree. Drafted by an emergency coalition of Crown legal advisors, Privy Council representatives, and outside family law experts, the document is said to span 94 pages across 6 annexes, a rare legal construct known internally as a dual-frame writ. It separates domestic civil law from Crown fiduciary protections, an instrument not invoked since the abdication settlement of Edward VIII in Itinjo by Saint-Chaleo. At its core lies Clause 14C, titled Media Exploitation and Identity Licensing, which triggered institutional alarm. This clause forbids either party from using the likeness, name, voice, or visual renderings of Archie or Lilibet in any monetized broadcast, merchandise, or intellectual property, including dramatizations, animations, audio products, and artificial intelligence likenesses, without written clearance from the Office of Royal Protections. The clause is reportedly irreversible, applies globally, and is enforceable through transnational copyright watchdogs. Meghan's refusal to sign Clause 14C was the pivotal moment that collapsed the settlement. According to sources within Gray's Inn, Meghan insisted on retaining future brand integration rights, particularly for Lilibet's likeness, which had already been modeled into early-stage concept art for a proposed children's book series titled Lily and the Lighthouse. Royal advisors interpreted this as a breach of the custodial neutrality requirement. Clause 14C wasn't about profit prevention, it was about psychological protection, explained Dame Rosalind Hurst, former Crown family law chair. The monarchy knows too well the trauma that comes when a child becomes intellectual property. Another key provision. Clause 7. Heritage access explicitly restricts any request by Meghan Markle or her representatives for future entry to any royal estate, royal cemetery, or Crown-funded institution under the pretense of ancestry, tradition, or symbolic continuity. This measure was seen as a direct block on any attempts by Meghan to insert herself or her children into official royal anniversaries, exhibitions, or charitable dedications. It's the equivalent of a royal erasure clause, said a senior Whitehall archivist. It doesn't just deny her access, it denies her interpretation. Perhaps the most controversial component, however, lies buried in Appendix 3, Custodial Compensation Framework. This annex details how all child-rearing costs, including education, healthcare, and housing for Archie and Lilibet, will be exclusively covered by the Crown, but only if the children reside full-time in UK-approved institutions or residences under royal guardianship protocols. Meghan's California residence, and any affiliate properties under Archewell, are explicitly disqualified. This provision, critics argue, essentially conditions support on territorial loyalty, forcing Prince Harry to either abandon California custody or forego all Crown financial guarantees for his children's safety. Palisades, however, have pushed back, insisting the clause is a direct defense against transatlantic exploitation and unverified third-party access. In an unprecedented step, Appendix 4 requires biometric image registration for both children under a secured vault at Sandringham Archives to prevent identity misuse in advertising, film, and AI training models. Legal experts believe this was triggered by rumors that unreleased childhood images had been sold in unauthorized back channels to Hollywood production houses. From a fiscal perspective, the document also nullifies any prior good faith subsidies issued to Harry and Meghan since 2020, converting them into callable debts under the Royal Privilege Reimbursement Statute. This retroactive shift reclassifies security expenditures, property renovations, notably Frogmore Cottage, and legal deferrals as misappropriated institutional funds. Any attempts by Meghan to challenge these debts in foreign courts would activate a diplomatic countermeasure known as Writ 77 Zeta, allowing the Crown to engage in reputational defense filings abroad. The agreement's communication clauses were no less severe. Section 12A, titled Narrative Freeze, bans all public interviews, memoirs, documentaries, or podcasts by either party that reference the children's conception, birth, baptism, or family holidays, unless expressly cleared by the Palace Legal and Legacy Office. Violations trigger automatic injunctions and asset holds on any affiliated production company, agent, or publisher. This clause appears to be in direct response to Meghan's unreleased audio memoir Mother of Grace, which insiders say included passages about Lilibet's birth meant to portray Meghan as a sole architect of SACE. Modern Royal Motherhood. The project has now been shelved indefinitely, according to Spotify sources. As for the emotional toll, multiple royal aides who witnessed Harry's February 15th signing described him as numb, hollow, but cooperative. In a chilling moment, when asked to initial a paragraph confirming he would no longer be the children's primary decision-maker on education, health, or location, Harry reportedly muttered, "If this spares them, I'll vanish myself." Behind the legalese, the settlement reveals a far deeper fracture. The monarchy's ultimate conclusion that the Markle brand poses a strategic risk not only to its image, but to its very continuity. As the clock struck midnight on the 15th of February 2026, a ripple of disbelief spread through Britain's legal and royal circles. The phrase, page 14, clause 7, trended worldwide within hours, cryptic to the public at first, but soon recognized as the defining legal weapon Meghan Markle had embedded within her 2018 marriage contract with Prince Harry. Unsealed in fragments during a confidential inquiry led by the Lord Chancellor's office, the clause was part of a sealed prenuptial agreement drafted under the advisement of U.S.-based legal firm Turner & Myers LLP. What made it so explosive was its scope. Clause 7 granted Meghan's sole intellectual property rights to Prince Harry's likeness, voice, unpublished memoir material, and all narrative derivatives involving their joint life from 2016 onward, including, crucially, the Sussex departure from royal duties in 2020. Legal analysts were stunned. "It's the most aggressive narrative control clause I've seen in any marital contract involving public figures," said Sir Malcolm Weatherby, former Queen's Counsel. Effectively, Harry surrendered control of his past, present, and future in exchange for marital unity and possibly emotional safety. This revelation shook not only royal advisors but also media conglomerates. Suddenly, Meghan's lucrative content deals from Netflix and Spotify to upcoming memoir serializations were seen in a new light. What had previously appeared to be joint Sussex branding now looked like a one-sided curation of Harry's legacy, filtered, edited, and licensed solely through Meghan's gatekeeping authority. According to Lady Louise Windsor, who co-authored the internal investigative summary for the Privy Council, the clause was never disclosed to senior royals. No one, neither Prince Charles at the time, nor Her late Majesty, was made aware of Clause 7 during the wedding proceedings, she stated in her private testimony. Had they known, it's unlikely any ceremonial recognition of the Sussex union would have proceeded as it did. Documents revealed that Meghan had insisted on American legal jurisdiction for all narrative rights disputes, a move that now haunts the royal family as they scramble to reclaim control over decades of institutional storytelling. Royal historians have long relied on regulated memoirs, letters, and archives preserved within the Windsor Archive. But if Meghan's interpretation of Clause 7 holds in court, entire chapters of Harry's royal life, childhood trauma, military service, personal reflections on Diana may now be commercially packaged without royal oversight. At the heart of this revelation was a single legal phrase: exclusive license to monetize and curate the narrative identity and legacy of the signatory. It appeared clinical, but its implications were staggering. Harry, by signing, had effectively authorized Meghan to become his publisher, producer, and biographer, with no obligation to involve him in any future projects. Insiders at Kensington Palace disclosed that Prince William was visibly shaken upon reading the unsealed documents. A source close to the Prince of Wales said, "It wasn't just betrayal, it was betrayal premeditated and inked in legalese." Queen Camilla, long silent on the Sussex issue, allegedly responded with a single line upon hearing the clause's scope. She wanted his story, not the man. The blow was not merely emotional. Buckingham Palace's media team, already tasked with countering negative Sussex-driven narratives, now faced the grim possibility that even future portrayals of the monarchy via documentaries, podcasts, or dramatized series could fall under Meghan's narrative purview, so long as they involved Harry. Public trust was fraying. Conservative MP Alden Brockhurst called for immediate legislative review of royal contracts involving foreign jurisdiction. "The crown must never again be undermined by an offshore clause drafted in Malibu," he said during an emergency House of Commons session. What made matters worse was Harry's apparent silence. Thus far, he had not disavowed the clause or attempted to revoke it. Sources within Clarence House believed Harry may not have fully understood the depth of what he had signed in 2018. "He was in love. And he was grieving his mother," said a senior aide. "He signed away the very thing Diana died fighting to protect, her children's autonomy." Meanwhile, Meghan's legal team issued a defiant statement late on February 16. The agreement in question was mutually approved, mutually signed, and remains legally binding. Attempts to retroactively nullify its contents constitute a violation of U.S. Civil Code and marital sovereignty. The timing was no accident. Meghan's upcoming memoir, reportedly titled The Spare's Crown, was set to hit shelves in April. If Clause 7 remained intact, the book's explosive chapters could include unreleased royal family conversations, private grief counseling notes, and even classified funeral preparations following Queen Elizabeth's passing. Princess Anne was reportedly incensed. During a closed-door Privy Council meeting, she demanded legal countermeasures and denounced Harry's signature as a breach of sovereign trust. Lady Louise reportedly echoed her aunt's outrage, stating, "If we do not act now, the Windsor legacy will be serialized, commercialized, and weaponized." But the family's next move would not be legal. It would be deeply personal and irrevocably public. What happened next would pit family loyalty against institutional protection, and for Prince Harry, force the question he had avoided for too long. Is love still binding when the contract behind it becomes a leash? By the 16th of February 2026, the full extent of Prince Harry and Meghan Markle's financial deterioration became irrefutable. For months, they had obscured the truth behind polished social media appearances and a smokescreen of brand extensions. But when news broke that the Montecito property was nearing foreclosure, complete with certified documents filed in Santa Barbara County, the narrative collapsed. At the center of this spiraling drama was a $9.4 million bridge loan secured against the property in mid-2025, originally structured through a Delaware-based holding entity that was later revealed to have ties to a now-defunct Dubai media syndicate. The loan's terms were unusually aggressive, carrying a 25% interest rate and a 9-month maturity. According to one leaked banker memo, the couple was warned of accelerated lien exposure and zero rollover flexibility. If repayments missed their January 31 deadline, they missed it. Meghan had quietly tried to negotiate refinancing behind the scenes, allegedly reaching out to a boutique lender in Manhattan that specialized in distressed celebrity portfolios. But the underwriters flagged the Archewell Foundation's audited statements, which under scrutiny showed inconsistencies in expense allocations, particularly regarding PR retainers and security reimbursements claimed as charity awareness. The deal fell apart within 72 hours. Public sentiment shifted overnight. What had once been interpreted as artistic rebranding or independent resilience now looked like financial recklessness. Their children, Archie and Lilibet, had already been discreetly pulled from a premium Brentwood private school and moved to a lower-cost Montessori-style program. Meghan's wardrobe had subtly transitioned from couture-heavy ensembles to more minimal, repurposed pieces, though her stylists insisted it was a sustainability choice. Then came the most humiliating blow. A leaked email from their former Netflix showrunner revealed that a proposed follow-up docuseries centered on Meghan's healing rituals and Harry's ancestral reckoning had been permanently shelved due to inadequate audience retention and reputational drag. The network had quietly decided not to renew their broader content agreement. A 5-project pipeline, once worth over $40 million, had vanished, replaced by a polite but damning phrase in the memo: brand underperformance with ongoing legal exposure. Insiders confirmed that King Charles and Prince William had known this moment was coming. A containment protocol was allegedly activated as early as January 20, when palace advisors flagged potential default risk based on SEC filings linked to Archewell's U.S. partner entities. The Crown's legal team had preemptively blocked any attempts by Harry to leverage Highgrove House, Sandringham Visuals, or any royal trademarks in future branded media, an unprecedented move in modern royal history. Princess Anne, ever the silent sentinel, made one veiled public statement during an event at the Royal Maritime College. "No title," she said plainly, "grants immunity from responsibility, only clarity of purpose protects legacy." To many, it was a final warning shot to Harry and Meghan. The monarchy was drawing a red line not just morally, but structurally. Meanwhile, California court watchers noted that Meghan's legal team had filed an unusual sealed motion in early February, suspected to be related to preemptive bankruptcy protections. If confirmed, this would block creditors from immediately seizing the Riven Rock property, but would also trigger disclosure requirements that could further expose Archewell's internal operations. One overlooked casualty in all of this was Prince Harry himself. Friends noted a marked change, unshaven appearances, confused public remarks, and a noticeable absence from recent Archewell live streams. In private, according to Palace insiders, Harry had reinitiated quiet back-channel communication with Prince Edward, not as a royal, but as a brother seeking clarity. The most chilling rumor? That Harry had asked whether his children still counted as Windsors, and if not, what legal framework governed their future. By mid-February, Montecito no longer stood as a sanctuary. It was a monument to hubris and financial miscalculation. Meghan reportedly canceled all upcoming media appearances, and her as-ever brand team had stopped responding to press inquiries. Only one official post was made on February 15, a vague quote about rising again through grace and grit. It received fewer than half the usual interactions. Meanwhile, the House of Windsor moved forward. Prince William was seen touring youth centers in Kent. Princess Catherine, serene but firm, opened a new cancer rehabilitation wing in Nottingham. The Crown had already pivoted its future oriented around duty, service, and institutional clarity. And Harry and Meghan, once global icons of modern reinvention, found themselves not just outside the palace gates, but uninvited, unheeded, and increasingly unwanted by the very public they once courted. The debts were not just financial, they were reputational, and in February 2026, the reckoning had come. By the 17th of February 2026, the British Royal Legal Council had finalized its preliminary assessment of the 2018 marriage contract between Prince Harry and Meghan Markle. The core alarm centered around page 14, Clause 7, a provision so broad, so sweeping in scope, it effectively gave Meghan unlimited editorial, creative, and financial rights to any representation of Harry's likeness, voice, digital presence, backstory, unpublished correspondence, and even his evolving perspective on the crown. The clause had once been brushed off by junior aides as a standard IP clause, common in American media prenuptials. But Lady Louise Windsor's relentless scrutiny revealed its full weaponized potential. According to legal records from 2022 to 2025, Meghan's team had already used Clause 7 to block several internal Windsor media projects that involved Harry's voice or image, including a planned documentary narrated by Harry's childhood friend, a Windsor Foundation campaign around mental health, and even a children's book that featured a fictionalized ginger prince. But now, with divorce on the horizon and the royal family actively distancing themselves from the Archewell collapse, the clause loomed like a legal guillotine. It meant Harry could not give an interview, memoir update, or even a statement about his own life without Meghan's written clearance. It meant she owned his version of himself. Princess Anne was livid. In a closed-door meeting at Clarence House, she allegedly slammed the document on the table and declared, "This is not a marriage. It's a licensing agreement." Meghan's defenders claimed the clause was protective, meant to shield against media distortion. But Lady Louise pointed out the pattern. Meghan had retained full commercial rights, while Harry had none. She had transferred those rights through Archewell's layered LLC structure to a Delaware-registered shell company called Echo Royal Media, now under investigation for financial misrepresentation. Even more concerning, the clause contained an automatic renewal mechanism every 18 months, unless one party actively voided it. Harry, lost in grief over his mother and confusion around fatherhood, had missed the July 2023 renewal window. Meghan hadn't. Backed into a corner, Harry's legal team submitted an emergency petition in California's Superior Court for declaratory relief of personal narrative reclamation. But the judge reportedly warned, "Your client signed, multiple times, and benefited from the arrangement until it no longer suited him." Behind the scenes, William was furious, not just with Meghan, but with Harry. "You let this happen," he was quoted saying during a private call intercepted by insiders. "You sold yourself, and now you want the crown to buy you back." It was cruel, but accurate. Meanwhile, Meghan's PR team leaked a counter-narrative to select media outlets, claiming Harry had gladly co-signed all creative rights to support their shared brand. They pointed to Heart of Two, their docuseries deal from 2021, where Harry had read pre-scripted lines, some drafted by Sunshine Sachs staff. But behind the romantic gloss was a brutal paper trail. Meghan controlled the edits. Meghan signed the licensing. Meghan alone had approval over every depiction of their love story. When Netflix lawyers reviewed Clause 7 during the production fallout of The Climb Within, they were stunned. It became clear why Harry was never allowed to speak freely on camera without cuts. Meghan's contract locked down not just his past, but his future. At a strategy meeting on the 18th of February 2026, Princess Anne gave her most decisive order yet. No further engagement with Harry's likeness until legal nullification of Clause 7. He is compromised. It was the most chilling moment in royal legal memory. A son of the crown declared non-viable for institutional use, not because of the scandal, but because of copyright. Meghan's strategy was now undeniable. While the press had painted her as a victim of control, she had quietly inverted the narrative. She controlled the story. She controlled the storyteller. She owned the prince. And unless something drastic changed, she would own his silence forever. As the palace's internal dossier was leaked to select British media outlets on the evening of the 19th of February 2026, one detail became impossible to ignore. The clause titled Contingent Custodial Jurisdiction, Archie and Lilibet. This section not only confirmed that neither child was registered within the Windsor family's official genealogical rolls, but also revealed damning inconsistencies in birth documentation, travel authorization, and biometric verifications. Royal observers and legal analysts alike declared this a historic threshold, marking the first time the monarchy had moved to publicly reject hereditary recognition for two children born to a royal son. Within hours, the Office of the Lord Chamberlain issued an addendum to the February 7 Order of Deroyalization, confirming that Archibald Harrison and Lilibet Diana shall no longer be associated with any privileges, protections, or ceremonial references pertaining to the British crown. The language was severe. The document emphasized clear and permanent separation from dynastic records and underscored ethical, legal, and national interest considerations as the motivating factors. For Meghan Markle, it was a total annihilation of the strategic narrative she had meticulously curated since her wedding in 2018. Her February 18 video featuring luxury decor, half-burned candles, and a performative monologue about the pain of silence was now parodied across social media, especially after the infamous As Ever brand collapse. Her public credibility was in tatters, and the hashtag number Ghost Royals began trending across Europe and North America. Inside Montecito, crisis meetings were reportedly held with 3 separate U.S.-based law firms, a pair of reputation management advisors, and an emergency intervention by Netflix executives. But the palace had already moved beyond narrative containment. Lady Louise Windsor and Princess Anne were said to have held a high-level meeting with royal archivists and biometric consultants from the Home Office to initiate the digital erasure of the children's honorary profiles from Commonwealth registries, ceremonial rolls, and even select royal memorabilia licensing agreements. The purge was total. Meanwhile, Prince Harry's silence grew deafening. Those close to the crown revealed that he had requested a private meeting with Prince William, not to beg for reconciliation, but to request guardianship transition assurances. According to insider reports, Harry's legal advisors feared that Meghan might attempt an emergency overseas relocation with the children, an act that, under the new declarations, would be classified as international custodial interference. But by then, Princess Catherine had already taken the lead. In a surprise appearance on February 20, Catherine visited a pediatric community center in West London. Though the event was scheduled weeks in advance, her wardrobe choice, a muted navy coat with a tiny rose gold brooch shaped like a shield, was read by analysts as a powerful visual signal. The brooch, never seen before, was quickly confirmed to be a custom design commemorating Windsor Protection Protocol 12, the very clause invoked to revoke Archie and Lilibet's status. When asked by a reporter about the children's well-being, Catherine responded with deliberate poise. Every child deserves stability, honesty, and care free from exploitation. The Crown stands ready to provide such protection, where necessary. The message was unmistakable. Elsewhere, Queen Camilla had gone utterly silent. Rumors circulated that her private secretary had submitted a classified inquiry requesting whether her own title might be at risk of formal revocation, given the fallout surrounding her initial defense of Meghan in earlier years. Though the palace denied this, the Queen Consort's absence from the latest events was seen as a strategic withdrawal, a sign that the Charles Anne William axis was now fully operational without her. In America, late-night hosts mocked the drama. "Imagine getting fired by your grandmother's ghost," one host quipped. Another called it the most British Game of Thrones season finale yet. But in the UK, the mood was markedly different. Polling conducted by Ipsos Mori the following morning showed that 73% of Britons supported the full removal of Meghan, Harry, and their children from royal affiliation. More tellingly, 61% supported Princess Catherine, assuming full symbolic guardianship over future generations of the monarchy. The House of Windsor, long accused of reacting too slowly or too timidly, had now drawn a brutal but clear boundary. The final curtain, however, was not dropped by a monarch or a duchess, but by the Crown Archives Office. At precisely 11:59 p.m. on February 20, the official Royal UK genealogy page was updated. Archie Harrison and Lilibet Diana were gone, replaced with a single footnote. Names formerly listed under Sussex designations removed by sovereign decree, per Protocol R. 24/6 and P. 12 jurisdiction. It was over. The experiment had ended. The monarchy had survived, and Meghan Markle, once hailed as a modern breath of fresh air, now stood alone amid the ruins of her brand, her narrative, and her crown-adjacent dreams. The Windsor firewall had held, and in doing so, it rewrote the rules of royal succession for a digital, post-truth era.